The letter arrived on a Tuesday, which Marcus Chen would later remember not because of the day, but because of what he was doing when he opened it. He was standing at the edge of the reservoir, his reservoir, watching the way the morning light moved across the water in long copper sheets, the way it had moved every morning for 23 years. He had his coffee. He had his silence. He had 240 acres of Pennsylvania land that his grandfather had shaped with his own hands, and the water that grandfather had gathered and held and left behind like a gift that kept renewing itself. It was, in the vocabulary of Marcus's interior life, a perfect moment. Then he opened the letter. It was from the Willowbrook Estates Homeowners Association, and it informed him, in the measured and impersonal language of institutional authority, that he was in violation of Community Aesthetic Standard 7.4, subsection C, regarding landscape maintenance along shared boundary corridors. The fine was $500. It was due within 30 days. Failure to comply would result in additional penalties accruing at a rate of $50 per day. Marcus read it twice. Then he looked up at the boundary line, his boundary line, where the manicured edge of Willowbrook Estates met the natural slope of his property. He had lived beside this boundary for 3 years now, since the development went in, and he had watched it transform from a tree line into something else entirely. Decorative lampposts, poured concrete walking paths, in a wrought iron fence that the HOA had installed on what they claimed was the community's perimeter. Though Marcus had measured it himself and knew that 18 inches of that fence sat on his land, he had not made an issue of it. He was not by nature a man who made issues of small things. He folded the letter. He put it in his pocket. He finished his coffee. That was the first letter. By the end of that year, there would be 11 more. Marcus Chen was 58 years old and had spent 4 decades as a civil engineer, which meant he understood systems, how they were built, how they failed, and most importantly, how the people who designed them almost always overestimated their own authority over the physical world. He was not a man given to drama or to grievance. He was a man given to precision, to the long view, to the understanding that most problems, if you looked at them with enough patience and enough technical clarity, revealed their own solutions. His wife Sarah called it his superpower and his affliction in equal measure. He would sit with a problem for months before he moved. And when he moved with the kind of certainty that made other engineers uncomfortable because it looked, from the outside, like arrogance, but was actually just the product of having done the work. He had done the work on this land. He knew every acre of it. He knew the watershed that fed the reservoir from the North Ridge, knew the seasonal fluctuation patterns his grandfather had documented in a series of engineering notebooks that Marcus kept in a fireproof cabinet in his study. He knew the dam, a modest earthen structure reinforced with concrete, and built in 1987 to his grandfather's specifications, permitted by the state of Pennsylvania as a private impoundment for agricultural water management. He knew the water. He had grown up swimming in it, had brought Sarah here before they were married, had stood at the dam gate on the morning his grandfather died, and understood, in the wordless way that grief sometimes delivers its truths, that this place was his responsibility now. He had not anticipated that it would become someone else's amenity. Willowbrook Estates had arrived the way development always arrives in rural Pennsylvania, gradually, then all at once. First the survey crews, then the clearing equipment, then the model homes rising from the adjacent 180 acres with a speed that felt almost biological, like something growing. But Marcus had watched it happen without alarm. He was not opposed to neighbors. He was not opposed to the reservoir becoming a scenic backdrop for a residential community. What he had not understood, in those early years, was that the HOA governing Willowbrook Estates would come to regard his reservoir not as a neighbor's private property, but as a community resource, and would come to regard Marcus himself not as a sovereign landowner, but as a problem to be managed. The water infrastructure had been the developer's doing. In 1995, before Marcus took full ownership of the property, his father had signed an easement agreement allowing the development to draw water from the reservoir through a pipeline connection at the southern edge of the dam. It was a practical arrangement, negotiated in good faith, and Marcus's father had understood it as a neighborly accommodation. The easement document was 12 pages long and written in the dense, subordinate clause-heavy language of real estate law, and Marcus's father, a farmer, not a lawyer, had signed it after a brief review by a general practice attorney in Harrisburg who had missed, or perhaps not understood, the significance of 3 words buried in Section 4, Paragraph 2. Upon written notice, Marcus would find those 3 words later, much later. But in the early months of the HOA's campaign, he did not yet know what he was looking for. What he knew was the fines. The first for landscape maintenance. The second for what the HOA called unauthorized modification of the boundary corridor, which turned out to mean that Marcus had trimmed a stand of wild sumac on his own property, and the HOA claimed this alteration affected the community's sightline to the water. The third fine arrived with a formal demand letter requiring Marcus to install decorative fencing along his eastern boundary, a specific style, a specific height, a specific color, to match Willowbrook's aesthetic standards. The cost of the fencing, Marcus estimated, would be approximately $14,000. The HOA did not offer to contribute. The HOA did not acknowledge that the land in question was not theirs. The letter simply stated the requirement and the deadline and the penalties for non-compliance in the same flat, administrative tone that all the letters used, as if the authority behind them was so obvious it required no justification. Victoria Ashford signed every letter. She was the HOA president, a former corporate compliance officer from Philadelphia who had retired to Willowbrook 4 years ago and brought with her an absolutist faith in the power of written rules. Marcus had met her once, at a community meeting he had attended out of a sense of civic obligation, and had found her neither cruel nor stupid. She was something more difficult than either. She was certain. She had the particular certainty of someone who had spent a career enforcing institutional standards and had come to believe that the existence of a rule was sufficient justification for its enforcement. She did not appear to have considered the possibility that her authority had limits. She did not appear to have considered Marcus's property rights as a constraint on her jurisdiction. She appeared to have considered the reservoir as a community asset and Marcus as its custodian, a custodian who was, regrettably, not meeting his obligations. The $50,000 environmental impact fee arrived in March. Marcus was running a routine agricultural drainage project on the north end of his property, a maintenance procedure his grandfather had performed every decade, documented in the engineering notebooks, permitted under his existing land use classification. The HOA sent a letter claiming the project threatened community water quality and invoking what they called custodial authority over the watershed. They demanded he halt the project immediately and pay the fee before resuming. They attached a legal memo, 12 pages, from a firm in Pittsburgh, asserting that the HOA's water infrastructure agreement gave them supervisory rights over any activity on Marcus's land that could affect the reservoir. Marcus read the memo carefully. He read it the way he read engineering reports, looking for the load-bearing assumptions, the places where the structure depended on something that hadn't been proven. He found several, but he also understood that the memo was not really an argument. It was a signal. It was the HOA telling him, in the language of institutional power, that they intended to treat his land as an extension of their authority, and that they had the resources to make that treatment expensive and exhausting. He hired a lawyer, a general practice attorney, competent and well-intentioned, who sent a letter challenging the fee and asserting Marcus's property rights. The HOA responded with a $2.3 million lawsuit. The number was designed to be paralyzing, and for a time, it was. The legal fees began immediately. The uncertainty was worse than the fees. The particular uncertainty of a man who knows he is right, but cannot yet prove it in the forum where rightness is decided. Sarah watched him at the kitchen table in the evenings, surrounded by documents, and said nothing, because she knew him well enough to know that he needed the silence to think. He thought about his grandfather, and about the notebooks, about the way the old man had talked about the reservoir not as a possession, but as a system, something that operated according to its own logic, its own physics, its own long-term rhythms that had nothing to do with whoever happened to be standing at the gate. Water is the only leverage that matters in a drought, his grandfather had said once, during a dry summer in the early 90s, when a neighboring farmer had come asking for access, and his grandfather had quietly, firmly explained the terms. Marcus had been 22 years old. He had not understood it then as a principle. He had understood it as a fact about water. He was beginning to understand it now as something else entirely. He pulled the original easement document from the fireproof cabinet. He sat down with it at the kitchen table, under the lamp, with the kind of attention he had not given it before. He was looking for something specific now. He was looking for the place where the HOA's certainty ended and his own authority began. He found it on page 4. The county recorder's office smelled like the inside of a filing cabinet. That particular combination of aged paper, fluorescent light, and institutional indifference that Marcus had always associated with bureaucratic permanence. He arrived at 8 in the morning, 20 minutes before the doors officially opened, and stood on the sidewalk in the November cold with a yellow legal pad and a thermos of coffee, waiting. The clerk who unlocked the door looked at him the way clerks always look at people who arrive before they are supposed to, with mild suspicion and the faint hope that whatever this person needed would be simple. It was not going to be simple. Marcus had spent the previous 3 weeks doing what engineers do when a structure fails. He went back to the original drawings, not metaphorically, literally. He had pulled every document he could find from the property's history. The deed his grandfather had recorded in 1961, the agricultural permits from the 1970s, the engineering specifications his grandfather had filed when he built the reservoir in 1987, and the transfer documents from when Marcus's father had inherited the land and then sold it to Marcus in 1996. What he found in those documents was not a mystery. It was a blueprint. And like any blueprint, it rewarded the person who was willing to read it carefully. He had started with the deed itself. The language was the kind of language that lawyers wrote before they learned to be deliberately vague, specific, declarative, unambiguous. The property was described in metes and bounds, a surveying method that traces a boundary by direction and distance, and the description included the reservoir explicitly. Not as a feature of the land, as a component of the property. The deed read, including all water impoundments, drainage structures, and water management infrastructure constructed or to be constructed thereon, together with all water rights appurtenant thereto, in perpetuity. Marcus had read that sentence 4 times the first night, sitting at his kitchen table with a magnifying glass and a glass of bourbon, and each time he read it he felt something shift in his chest. Not hope exactly, but the structural recognition that the foundation was sound. Whatever had been built on top of it was the problem. The foundation itself had never moved. The reservoir was his, the water was his. The deed said so in 1961, and no subsequent document had changed that. But deeds are only the beginning. What Marcus needed to understand was the 1995 easement the agreement his father had signed with the developer who first began converting the adjacent land. He found it in the county recorder's files on his second day of searching, misfiled under the developer's corporate name rather than the property address, which explained why no one had apparently looked at it carefully in 25 years. It was 11 pages long, single-spaced, and written in the kind of legal language that is designed to appear comprehensive while actually being quite precise about what it does and does not grant. Marcus read it 3 times in the records room, then photographed every page, then read it again that evening with a highlighter. The easement granted the developer, and by succession the Willowbrook HOA, the right to draw water from Marcus's reservoir through a specified intake pipe for residential and community use. It granted this right as a non-exclusive easement, meaning Marcus retained the right to use the water himself. It specified the maximum daily draw volume. It required the HOA to maintain the intake infrastructure on their side of the property line. And then, on page 9, in a subsection titled Termination Conditions, it said this: "The easement granted herein shall be revocable by the grantor upon 180 days written notice, in the event that the water source becomes inadequate for the grantor's primary agricultural and residential use, or in the event that the grantee materially breaches the terms of this agreement." 180 days. Written notice. 2 conditions, either of which was sufficient. Marcus set down the highlighter and looked at the ceiling of his kitchen for a long moment. The HOA had been fining him for landscape maintenance on his private property. They had demanded he install decorative fencing on land they did not own. They had restricted his access to his own reservoir, requiring written requests 72 hours in advance. They had imposed a $50,000 environmental impact fee on an agricultural maintenance project he had every legal right to conduct. They had sued him for $2.3 million and demanded he formally cede his water rights to them in perpetuity. Every one of those actions was a potential material breach of the easement agreement, because the easement agreement, on page 3, contained a covenant of non-interference. The grantee shall not interfere with the grantor's lawful use and enjoyment of the property from which this easement is drawn. They had not just overreached, they had overreached against the very document that gave them their water. He called David Rothstein the next morning. Rothstein was a water rights attorney based in Philadelphia, recommended by a colleague from Marcus's engineering firm who described him as someone who genuinely enjoyed cases where the other side had made a catastrophic assumption. Marcus had explained the situation in a 40-minute phone call, and Rothstein had been quiet for most of it, the kind of quiet that is not disengagement, but concentration. When Marcus finished, Rothstein said, "Send me everything, all of it. Don't filter it. Send me the deed, the easement, the fines, the HOA's legal filings, the correspondence, the photographs, everything." Marcus sent it that afternoon. Rothstein called back in 2 days. What Rothstein had found, and what he explained to Marcus over a 2-hour call that Marcus recorded with Rothstein's permission, went beyond what Marcus had already discovered. Rothstein had pulled the Pennsylvania Water Resources Planning Act and cross-referenced it with the reservoir's original 1987 engineering permits. The reservoir was classified in the state's own records as a private impoundment, a designation that carried specific legal protections. Private impoundments in Pennsylvania are not subject to municipal water authority jurisdiction. They are not public utilities. They are private property, and the owner's rights over them are treated with the same legal weight as rights over any other private structure. The HOA had been behaving as though the reservoir were a community asset, as though their dependence on it conferred some form of authority over it. In their legal filings, they had used the phrase custodial authority over the watershed, a phrase that Rothstein described, "ent with professional restraint," as legally invented. There was no such doctrine in Pennsylvania water law. There was no such doctrine anywhere. The HOA's lawyers had constructed an argument from the assumption that physical dependence creates legal authority, and that assumption was wrong in every jurisdiction Marcus could think of. But Rothstein had found something else, something that Marcus had not looked for because he had not known to look for it. He had contacted a state hydrologist, a woman named Dr. Patricia Osei at Penn State's Water Resources Department, and asked her to pull the regional drought projections for southeastern Pennsylvania. What Dr. Osei sent back was a summary of a 2019 state report that had received almost no public attention. The region was entering what the report called a decadal drought cycle, and just a pattern of reduced precipitation and elevated evaporation rates that the modeling suggested would persist through at least 2031. The reservoir's water level, which was currently adequate, would begin declining by 2022 under normal usage patterns. Under the HOA's current draw rate, which had increased by 31% since 2017 as the community grew, the reservoir would reach what the report called critical threshold levels within 4 to 6 years. Marcus had read this section of Rothstein's summary 3 times. Then he had walked outside to the edge of his property and looked at the reservoir in the grey November light. The water still and flat and grey-green, the surface undisturbed, the dam at the southern end solid and unremarkable, the way all load-bearing structures look when they are doing their job. He had built his career on understanding what structures could bear and what they could not. He understood, standing there, that what he was looking at was not just a reservoir. It was a clock. The HOA did not know the clock was running. They did not know because they had never looked at the deed. They had never read the easement carefully. They had never checked the state's water records. They had built 94 homes and an entire community governance structure on the assumption that the water would always be there, that the man who owned it would always comply, and that their institutional authority was sufficient to manage any challenge that arose. They had built on sand and called it bedrock. Marcus understood something that afternoon that he had not fully understood before. He had been approaching this as a legal problem, as a fight he needed to win in court, a matter of defending his rights against an institution that had violated them. And it was that. But it was also something else. It was a structural problem. And structural problems, in Marcus's experience, do not resolve through argument. They resolve through load. You apply the correct force at the correct point, and the structure either holds or it doesn't. He had the correct force. He had the correct point. What he needed now was the patience to apply it at the correct moment. Not in anger, not in retaliation, but with the cold precision of an engineer who has read the blueprints and knows exactly where the weight needs to go. He went back inside and called Rothstein. They talked for another hour. By the end of the call, they had the outline of a strategy. Not a threat, not a bluff, but a methodical legal process that would force the HOA to confront what they had never bothered to understand. That the water sustaining their community belonged to a man they had spent 3 years trying to control, and that the document giving them access to it contained a door they had never noticed with a lock that only Marcus could open. He did not feel triumphant. He felt the way he felt at the beginning of a complex engineering project, the particular clarity that comes when you have read the specifications carefully enough to understand both what is possible and what the work will cost. He picked up his legal pad and began to write. David Rothstein's office smelled like old paper and cold coffee, which Marcus found reassuring. A lawyer whose office smelled like mahogany and ambition would have worried him. This man worked. The stacks on his desk were not decorative. The yellow legal pads were full. The window behind him looked out onto a parking garage, and Rothstein had never bothered to hang curtains. which told Marcus everything he needed to know about where this man's attention went. He had been referred by a colleague at the State Engineering Board, someone who described Rothstein in a single sentence. He once made a county commissioner cry in open court over a drainage ditch. Marcus had called that afternoon. He spread the documents across the conference table in the order he had organized them at home, which was the order of their legal weight, not their chronology. Rothstein watched without touching anything. His reading glasses pushed up onto his forehead, his arms crossed. He let Marcus talk for 11 minutes without interruption, which was also reassuring. When Marcus finished, Rothstein pulled the 1995 easement agreement toward him with 2 fingers, the way a surgeon lifts a piece of tissue to examine what's beneath it. He read it once, then he read it again. Then he set it down and looked at Marcus with an expression that was not quite a smile, but was adjacent to one, the expression of a man who has just been handed something he recognizes. They never read this, Rothstein said. The HOA, their lawyers, their developer, whoever negotiated the water infrastructure for Willowbrook Estates. They saw the word easement and they stopped reading. He tapped the document. An easement sounds permanent. It sounds like a right. Most people treat it like one. But this, he tapped again, this is a license dressed in easement language, and whoever drafted it in 1995 either didn't know the difference or didn't care, because the grantor, your father, had no intention of giving anything away permanently. Marcus had read the relevant clause so many times he could recite it. He recited it now, not from memory, but from the document Rothstein was holding, because he wanted to hear it said aloud in this room, by his own voice, in the presence of a lawyer who understood what it meant. Upon 180 days' written notice, Marcus said, if the water source becomes inadequate for the grantor's primary agricultural and residential use. Rothstein nodded slowly. That clause is the whole case. Everything else is scaffolding. The HOA's original lawsuit, the $2.3 million action that had been bleeding Marcus for 14 months, rested on a single foundational assumption, that the easement was permanent, that it had been absorbed into the community's infrastructure with the implicit consent of the property owner, and that Marcus's resistance to HOA authority constituted interference with a vested community right. Their legal memo, which Marcus had read with the focused fury of a man reading his own indictment, used the phrase established water dependency 11 times. It was a phrase designed to sound like a legal standard. It was not. Rothstein had already confirmed that what the HOA had built in legal terms was a cathedral on a foundation they had never inspected. While Rothstein spent the next hour walking Marcus through the architecture of the countersuit. It was not aggressive in tone. That was deliberate. Aggression, Rothstein explained, gives the other side something to perform outrage about. Precision gives them nothing to hold on to. The filing would be surgical, a declaratory judgment action establishing the easement's revocability, a counterclaim for tortious interference with property rights, a separate claim under the Pennsylvania Uniform Condominium Act for the HOA's attempts to impose authority over land outside its jurisdiction. The fines, Marcus said, the $500 a month for landscaping, documented and included, every one of them. The $50,000 environmental impact fee. That one, Rothstein said, is almost beautiful in how overreaching it is. They have no statutory authority to levy that fee. None. They invented a power they do not possess, and then invoiced you for it. We will enjoy that one. Marcus thought about Victoria Ashford, sitting in her HOA board meetings, her compliance officer's mind organizing the world into categories of permitted and prohibited, her certainty that the rules she enforced were the rules that governed reality. He did not hate her. He had tried to, in the early months. When the certified letters arrived weekly, and his wife stood at the kitchen counter reading them with the particular stillness of a person absorbing damage. But hatred required a kind of energy he had decided to redirect. What he felt instead was something colder and more useful. He felt the patience of a man who understood systems, who had spent 40 years calculating load tolerances and water pressure and the precise stress points where structures fail. He had looked at the HOA's legal position the same way he looked at a flawed engineering design. He had found the failure point. Now he was applying pressure to it with professional care. "There's something else," Marcus said. He pulled out the second folder, the one he had not shown to his previous lawyer, the one he had assembled over 3 months of evenings with state hydrological surveys, USGS groundwater reports, and a conversation with a former colleague at the Pennsylvania Department of Environmental Protection. He laid the documents in front of Rothstein in a specific sequence. Rothstein read them without speaking. The parking garage outside the window was filling with afternoon shadow. Somewhere in the building a phone rang and went to voicemail. "A 10-year drought cycle," Rothstein said, finally. "Beginning in 2022, possibly earlier. The groundwater recharge rates in this county have been declining since 2017. The reservoir is currently at 78% capacity. In a sustained drought, that number drops." Marcus had run the calculations himself, 3 times, using 2 different hydrological models. The HOA has no backup water source. The municipal line is 12 miles from the development. The infrastructure cost to extend it is somewhere between $7 and $9 million. Rothstein set the documents down. He looked at Marcus for a long moment. "You're not just defending yourself," he said. No. You hold the water. I hold the water." It was the first time Marcus had said it plainly, without qualification, without the hedging instinct of a man who had spent over a year being told by lawyers and HOA notices and $2.3 million lawsuits that he was the problem. He held the water. His grandfather had built the reservoir with private capital and private engineering permits in 1987, and the deed recorded at the county courthouse, in language that had not changed in 36 years, conveyed to Marcus Chen and his heirs the water rights to that impoundment in perpetuity. The HOA had built 94 homes on the assumption that this fact did not matter. They had fined him and restricted him and sued him on the assumption that their institutional weight was heavier than a property deed. They had miscalculated the weight of the deed. Rothstein did not recommend threatening the water supply. He was explicit about this, and Marcus had not needed the warning. A threat was a negotiating position. A legal filing was a statement of fact. The countersuit would establish, in the public record of the Pennsylvania court system, that the easement was revocable upon proper notice, that the HOA had no authority over Marcus's land, and that every fine, every restriction, every demand letter had been issued without legal foundation. It would not mention drought projections. It would not mention the absence of backup infrastructure. It would not need to. The HOA's lawyers would read the filing. They would read the easement clause. They would look at the map of Willowbrook Estates and count 94 homes. They would make the calculation themselves. "When do we file?" Marcus asked. "I want 2 more weeks to finish the documentation review. I want to make sure every fine is catalogued, every letter is dated, every restriction is on record." Rothstein stacked the documents with the efficiency of a man who had already begun organizing his argument. "I want this to be airtight before it becomes public, because once we file, the HOA will have a choice. They can settle quietly, or they can fight publicly. And if they fight publicly, the community finds out what the easement actually says. The community finds out what the easement actually says," Rothstein confirmed. "And then they start asking questions about their water supply that the HOA board will not enjoy answering." Marcus drove home through the October dark, and past the stone entrance pillars of Willowbrook Estates with their polished brass lettering, past the decorative fencing the HOA had demanded he install on his own property, past the reservoir that sat behind his tree line like a held breath. The water was dark and still, and entirely his. His grandfather had told him once that the man who controls the water controls the conversation. Marcus had been a child when he heard it, and had filed it away as the kind of thing old men said, true in some abstract sense, irrelevant to the modern world of contracts and courts and institutional authority. He understood now that his grandfather had been a more precise engineer than he had realized. The conversation was about to change. The first egg hit the side of Marcus's truck on a Tuesday morning in March. He heard it from inside the house, a wet, percussive slap against the driver's side door, and stood at the kitchen window long enough to watch a teenager in a Willowbrook lacrosse hoodie jog back across the property line and disappear into the tree line. Marcus set down his coffee. He did not call the police. He went to the garage, got a bucket and a sponge, and cleaned the door in the cold. That was how it started. Within 2 weeks, someone had spray-painted the word "selfish" in red letters across the wooden gate at the end of his access road. Within a month, his mailbox had been knocked off its post twice. A petition circulated through the Willowbrook Estates community portal, a slick, HOA-branded digital platform that Victoria Ashford had championed as a tool for civic engagement, demanding that local county commissioners investigate Marcus's deliberate obstruction of community infrastructure. It gathered 340 signatures in 4 days. Marcus's name appeared in the subject line of the petition, like a verdict. He read it on his laptop at the kitchen table, while Sarah stood behind him, her hand on his shoulder, not saying anything. There was nothing to say. The petition did not contain a single factual error that a layperson would recognize. It described the reservoir as shared community infrastructure. It described Marcus's legal counterclaim as an aggressive attempt to weaponize a private property dispute against 94 families. It described Victoria Ashford as a tireless advocate working to protect the community's most essential resource. Every sentence was technically constructed to be believed. Marcus closed the laptop. "They're scared," Sarah said. "They don't know they should be scared yet," Marcus said. "Right now they're just angry." That distinction mattered to him. Anger was reactive, emotional, and ultimately manageable. Fear, the specific, cold fear of understanding what you stood to lose, was something else entirely. The community was not yet afraid because they did not yet understand what the reservoir actually was, who actually owned it, and what the law actually permitted. Victoria Ashford had made sure of that. She had been extraordinarily careful to frame every public communication around Marcus's behavior, rather than the HOA's legal exposure. It was the work of someone who had spent a career in corporate compliance, someone who understood that the most dangerous information is the information you prevent from entering the room. The community meetings were the worst of it. Marcus attended one in April, against David Rothstein's advice. He sat in the back of the Willowbrook Community Center, a building that had been constructed on the eastern edge of the development, its parking lot graded toward the reservoir's drainage field, and listened to Victoria Ashford stand at a podium and describe him to his neighbors as a man who had chosen litigation over cooperation, your grievance over community, and personal gain over the welfare of 94 families. She wore a blazer the color of slate. She spoke with the measured cadence of someone who had rehearsed not just the words, but the pauses between them. Mr. Chen has filed a legal action that, if successful, would allow him to terminate water access to every home in this community, she told the room. We want to be transparent with you about that threat. We also want to be clear that the HOA board is committed to protecting your rights, your property values, and your access to the resources this community was built around. Someone in the third row asked whether the HOA had a contingency plan. Victoria did not hesitate. We are in active consultation with county water authorities and infrastructure specialists. We are not going to allow one individual's legal maneuvering to determine the future of this community. Marcus watched the room absorb this. He watched people nod. He watched a woman in the second row, a woman he recognized as the mother of the boy in the lacrosse hoodie, lean over and whisper something to her husband, who nodded grimly. He watched the fear that was not yet fear arrange itself into something more comfortable: certainty. The certainty that the HOA was handling it. The certainty that Marcus was the problem. The certainty that institutions built to protect you would, in fact, protect you. He left before the meeting ended. He drove home on the county road that ran along the reservoir's western edge, and he pulled over for a moment and looked at the water in the early evening light. The reservoir was holding well. The winter snowpack had been adequate. The surface was calm and flat, and reflected the tree line in perfect, undisturbed detail. It did not look like leverage. It looked like a lake. But Marcus had spent 40 years reading water. He knew what the state hydrologist's projections meant in practical terms. He knew what a 10-year drought cycle did to a private impoundment of this size, with no tributary recharge. He knew that the reservoir's current health was a photograph, not a promise. A single frame from a film that was already moving in a direction the community did not understand, and the HOA had not disclosed. He pulled back onto the road and drove home. The social pressure intensified through May and into June. A local news station ran a segment, 3 minutes and 40 seconds, in which Marcus timed. That described the dispute as a David and Goliath story in reverse, casting the HOA and its 94 homeowners as the vulnerable party, and Marcus as a landowner exploiting an obscure legal technicality to avoid accountability. The reporter had clearly been briefed by someone close to the HOA's communication strategy. The segment did not mention the revocability clause. It did not mention the $50,000 environmental impact fee. It did not mention the $2.3 million lawsuit the HOA had filed against Marcus. It mentioned twice that Marcus had refused to comment. He had refused to comment on Rothstein's instruction. Litigation strategy, not cowardice. But the silence read as guilt to people who wanted it to. His neighbor to the north, a farmer named Gerald Purcell, who had known Marcus for 15 years, stopped waving when their trucks passed on the county road. That was the one that landed differently. Not the petition, not the spray paint, not the news segment. Gerald Purcell, who had borrowed Marcus's tractor twice and returned it with a full tank of diesel both times, who had helped Marcus clear a downed oak from the access road after a storm in 2017, who had never had a single reason to think poorly of Marcus Chen. Gerald Purcell had decided, based on a 3-minute 40-second news segment and a community petition, that Marcus was the kind of man who deserved to be not waved at. Marcus mentioned it to Rothstein during a phone call that week. Rothstein was quiet for a moment. "That's what they're counting on," he said. "Social isolation is a pressure tactic. They want you to settle because you can't stand the community thinking badly of you." "I know what it is," Marcus said. "Then you know you can't let it move you." Marcus looked out the window at the reservoir. The water level was exactly where he expected it to be for early June. In 2 months it would begin its seasonal decline. In 2 years, if the projections held, the decline would not be seasonal. It would be structural. The HOA had built an entire community on the assumption that the water would always be there, always be accessible, always be someone else's problem to manage and maintain and protect. They had built 94 lake houses on his reservoir and told themselves the lake belonged to everyone. They had fined him for the grass along his own fence line, and that they had charged him $50,000 for moving dirt on his own land. They had filed a lawsuit demanding he surrender, in perpetuity, the one thing his grandfather had understood well enough to deed to him with absolute clarity. And now they had turned his neighbors against him. Marcus was not a man who believed in fate. He was a civil engineer. He believed in load-bearing calculations and hydrostatic pressure and the precise, indifferent mathematics of water moving through a landscape according to physics rather than preference. He believed that structures fail not because of malice, but because of the gap between what was assumed and what was true. The HOA had assumed a great many things. The summer was coming, the drought was coming, and David Rothstein was already drafting the next set of interrogatories. Questions so specific, so technically precise, that answering them honestly would require the HOA to admit on the record exactly how completely they had built their community on ground they did not own and water they did not control. The community had turned against Marcus Chen. They had done it publicly, efficiently, and with the full institutional weight of the Willowbrook HOA behind them. They had no idea they were turning against the man who held the gates. The summer of 2022 did not arrive gradually. It did not ease into the region the way Pennsylvania's summers usually did, with weeks of tentative warmth and afternoon thunderstorms that smelled like cut grass and wet concrete. It arrived like a verdict, like something that had been decided long before anyone thought to prepare for it. By the second week of June, the temperature had broken 93 degrees on 11 consecutive days. The lawns of Willowbrook Estates, which the HOA maintained to a standard that required specific blade heights and seasonal color rotations, began to yellow at the edges. The ornamental grasses that lined the community's entrance boulevard went brittle. The flowering borders around the clubhouse, which Victoria Ashford had personally selected from a landscape architect's catalogue the previous autumn, curled inward on themselves like fists. Marcus watched it from his porch. He watched it the way a man watches something he has been expecting for a long time, not with satisfaction, not with cruelty, but with the particular stillness of someone who has already done the math and knows what the numbers mean. He had a cup of coffee in his hand. He had the State Hydrologist 2020 report on the table beside him. He had been reading it again, not because he needed to, but because precision mattered to him. He wanted to be sure he had not misremembered anything. He had not. The reservoir behind his property, his grandfather's reservoir, built in 1987 with engineered berms and a concrete spillway and a gate system that his grandfather had designed himself because he trusted his own hands more than he trusted contractors, was already 4 feet below its normal June waterline. 4 feet, in the second week of June. Marcus had been measuring it every morning since April, though recording the levels in a notebook with the same methodical consistency he had applied to every structural problem in a 40-year engineering career. The numbers formed a line. The line was not ambiguous. He called David Rothstein that morning. Rothstein picked up on the second ring, which was how he always picked up, because Rothstein understood that this case had moved past the phase where anything could be allowed to wait. Marcus told him the reservoir was at 61% capacity. He told him the National Weather Service had issued a drought watch for the county 2 days ago. Not a warning, not yet, but a watch, which meant the meteorological conditions for severe drought were present and the forecasters were no longer willing to say it wouldn't happen. He told him that based on the drawdown rate he had been observing since April, and based on the HOA's current consumption levels, which he had calculated from the easement's flow measurement records, the reservoir would reach critical threshold, the point at which his grandfather's original engineering specifications defined the water as insufficient for primary agricultural and residential use, sometime in late August or early September if the drought continued. Rothstein was quiet for a moment. Then he said, "How confident are you in that timeline?" Marcus said, "I'm a civil engineer. I built water management systems for the Army Corps of Engineers for 19 years. I'm confident." Another pause. Then Rothstein said, "Good. Don't touch the gates. Don't adjust anything. Don't do a single thing to the water system that you wouldn't have done on any other summer. I need this to be nature, Marcus. I need this to be the drought doing exactly what the drought does. You understand? Marcus understood. He had understood from the beginning. The power he held was not the power to act. It was the power to simply stop preventing the inevitable. The easement gave the HOA the right to draw water from his reservoir. It did not give them the right to water that wasn't there. Across the fence line, the decorative aluminum fence the HOA had demanded he install along the eastern boundary of his property, which he had refused, which had generated 3 separate violation notices and a cumulative fine that now stood at $4,200. The Willowbrook community was beginning to feel the season in ways that went beyond aesthetic inconvenience. The reservoir-fed irrigation system that kept the community's common areas green had been running on extended cycles since May, trying to compensate for the heat. Marcus could hear it at night, the tick and hiss of sprinkler heads, the system working harder than it was designed to work, drawing more than it had ever needed to draw. He did not say anything. He recorded the consumption in his notebook. Victoria Ashford called an emergency HOA board meeting on June 19th. Marcus knew about it because his neighbor, a retired schoolteacher named Gerald Pruitt, who had quietly refused to participate in the campaign against Marcus and who felt a persistent, low-grade guilt about the community's behavior, told him. Gerald was not a spy. He was simply a decent man who thought Marcus deserved to know that his name was being discussed in a meeting he had not been invited to attend. The meeting, according to Gerald, lasted 2 hours and 40 minutes. Victoria had presented a water conservation plan, mandatory restrictions on personal irrigation, a temporary suspension of the car washing stations near the clubhouse, a request that residents voluntarily reduce shower times. She had framed it as a proactive community response to regional drought conditions. She had not mentioned Marcus by name. She had not mentioned the easement. She had not mentioned the word revocable. But she had mentioned, in a tone that Gerald described as controlled but not entirely steady, that the HOA's legal team was monitoring the situation with the adjacent property owner, and that the board was confident in the community's water security. Confident. Marcus wrote that word in his notebook too, not because it was a measurement, but because it was a data point of a different kind. Confidence without foundation was its own form of engineering failure. He had seen it before, in load-bearing calculations that assumed materials would perform beyond their rated capacity, in flood projections that assumed rainfall would stay within historical averages. Confidence without foundation did not prevent collapse. It just meant that the people inside the structure were still smiling when the walls came down. The HOA's lawyers had sent a letter the previous month, their 4th letter since Rothstein had filed the counterclaim, reiterating their position that the easement was permanent and non-revocable, citing a 1998 amendment that they claimed superseded the original 1995 language. Rothstein had read the amendment carefully. He had read it the way Marcus read engineering specifications, looking not for what the document said, but for what it assumed. The 1998 amendment modified the flow rate provisions. It said nothing about revocability. The HOA's lawyers had apparently decided that silence on the question was the same as resolution of the question. It was not. Rothstein had written back to explain this in precise, ungentle terms. The HOA had not responded to that letter. That silence was also a data point. By the end of June, the reservoir was at 54%. The drought watch had been upgraded to a drought warning. The Pennsylvania Department of Environmental Protection had issued a guidance document recommending that private water system operators assess their capacity and notify dependent users of any anticipated shortfalls. Marcus read the guidance document twice. He sent a copy to Rothstein. Rothstein sent it to the HOA's lead counsel with a brief cover note that said only, "Please advise your client to review Section 4, Paragraph 2, regarding notification obligations for private impoundment operators." Section 4, Paragraph 2 said that private impoundment operators were not legally required to maintain water supply to easement holders if doing so would compromise the operator's primary use designation. It said that in conditions of documented drought, the operator's agricultural and residential needs took legal precedence over easement access. It said, in the careful language of regulatory guidance, exactly what Marcus's grandfather had written into the original easement 27 years ago, because his grandfather had been a man who understood that water was leverage and that leverage needed to be documented. Marcus walked out to the dam on the last evening of June. The sun was going down behind the western tree line, and the light on the water was the color of old copper, and the reservoir was beautiful in the way that things are beautiful when you understand their true nature. It was not a lake. It had never been a lake. It was a water management system, engineered, measured, or purposeful, and it had been built by a man who understood that the land and the water and the rights attached to both of them were not abstractions. They were real. They were recorded. They were his. He stood at the gate mechanism, the hand-operated sluice gate that controlled the outflow into the easement pipeline, the gate that fed every tap and toilet and garden hose in 94 houses across the fence line. And he put his hand on the wheel. He did not turn it. He simply held it. He felt the weight of it, the cold iron, the slight resistance of a mechanism that had not been adjusted in years because there had never been a reason to adjust it. He thought about his grandfather, who had built this dam with his own hands and then told his grandson that water was the only leverage that mattered in a drought. He thought about the 180-day notice provision in the easement, which Rothstein had not yet deployed, which was sitting in a legal document in Rothstein's office, like a loaded instrument waiting for the precise moment when its use would be not just legal, but irrefutable. He thought about Victoria Ashford, standing in front of 94 families, telling them she was confident in their water security. He took his hand off the wheel. He walked back to the house. He picked up his notebook. He wrote down the date, the reservoir level, the ambient temperature, and the current drawdown rate. He calculated the projected level for August 15th, September 1st, and September 15th. Then he called Rothstein and told him it was time to start preparing the notice. Not to send it, not yet, just to prepare it, because precision mattered. Because timing mattered, because the difference between leverage and cruelty was knowing exactly when to act and exactly when to simply let the drought do what droughts do. The reservoir was at 54%. The summer was not finished. The conference room on the 14th floor of Hargrove and Associates smelled like recycled air and institutional anxiety. It was a Tuesday in March, and outside the floor-to-ceiling windows, Philadelphia's skyline sat gray and indifferent beneath a sky the color of old concrete. Marcus Chen arrived 12 minutes early. He always arrived early. It was the habit of a man who believed that time, like water, flowed in one direction and rewarded those who understood its movement before others did. He sat down, opened his legal pad, uncapped his pen, and waited. But David Rothstein arrived 2 minutes later, set a banker's box on the table with the quiet confidence of a man depositing a loaded weapon, and said nothing. He didn't need to. They had spent 4 months preparing for this day. They had rehearsed every question the HOA's attorneys might ask. They had mapped every exit the HOA might attempt and closed each one methodically, the way you close floodgates, one at a time, in sequence, without drama. Victoria Ashford arrived with 3 attorneys. Marcus noticed that immediately. Not 1, not 2, 3. The kind of legal firepower you deploy when you are genuinely afraid, when the thing you are defending has revealed itself to be more fragile than you publicly admitted. She wore a charcoal blazer and the expression of someone who had spent the previous night convincing herself she was still winning. She did not look at Marcus when she sat down. That told him everything. The lead HOA attorney was a man named Gerald Fitch, mid-50s, silver-haired, the kind of lawyer who had built a career on making complicated things sound simple, and simple things sound complicated. He had a reputation in Pennsylvania property law circles for aggressive discovery tactics and theatrical cross-examinations. He had also, Marcus knew from Rothstein's research, never litigated a water rights case of this specific complexity. He was a community association specialist. He knew HOA bylaws the way a locksmith knows deadbolts. But this was not a deadbolt. This was a dam. The deposition began with the procedural formalities, names stated for the record, oaths administered, ground rules established. Then Fitch opened his folder and smiled the smile of a man who believed he was about to dismantle something. He started with Marcus's property records. Standard territory. When did you purchase the land? What was the purchase price? Have you ever subdivided the parcel? Marcus answered each question in the flat, precise cadence of a civil engineer. No elaboration, no editorializing, no emotional coloring. Just data, just facts, just the architecture of the truth. Load-bearing wall by load-bearing wall. Then Fitch moved to the reservoir. Mr. Chen, can you describe the physical dimensions of the impoundment located on your property? The reservoir covers approximately 41 surface acres at full capacity. The dam structure is earthen-fill construction, approximately 60 feet at its highest point. Total storage capacity is roughly 890 million gallons. Fitch nodded, made a note. And you claim ownership of this water resource. I don't claim it, Marcus said. I own it. The deed is unambiguous. The water rights were conveyed to my grandfather in 1987 as part of the original construction permits issued by the Pennsylvania Department of Environmental Protection. They transferred to my father in 1991 and to me upon purchase in 1996. The chain of title is continuous and uncontested. Fitch moved on quickly. Too quickly. Marcus filed that away. The deposition shifted to the 1995 easement agreement, the document that had allowed the Willowbrook developer to connect the community's water infrastructure to Marcus's reservoir. Fitch's approach here was careful, almost delicate, the way you approach a structure you suspect might be load-bearing and are not entirely sure you want to test. The easement agreement of 1995, in your interpretation, does that agreement grant Willowbrook Estates ongoing access to the reservoir? It grants a non-exclusive, revocable license to draw water from the reservoir under specific conditions. Revocable, Fitch repeated, as though the word had surprised him, though it hadn't. He had read the document. He knew what it said. What he was doing was testing whether Marcus would soften it, qualify it, leave a thread he could pull later. Marcus did not leave threads. Revocable, he confirmed. Upon 180 days written notice, if the water source becomes inadequate for the grantor's primary agricultural and residential use. That language is in Section 4, Paragraph 2 of the original agreement. It has never been amended. The room shifted. It was not a dramatic shift. No one stood up. No one raised their voice. But something in the atmospheric pressure of the conference room changed. The way pressure changes in a structure when a critical joint begins to fail. One of Fitch's co-counsels leaned forward and wrote something on a notepad and slid it across the table. Fitch did not look at it immediately. He was too experienced to show that kind of tell, but he looked at it eventually, and when he did, the slight tightening around his eyes was the only evidence Marcus needed. They had not fully processed the revocability clause, or they had processed it and convinced themselves it was theoretical, a legal artifact that would never be exercised because no rational property owner would actually terminate water access to 94 homes. They had built their entire legal strategy on the assumption that Marcus's leverage was leverage he would never use. Rothstein had anticipated this. He had told Marcus in their last preparation session that the HOA's fundamental miscalculation was not legal. It was psychological. They could not imagine a man who would actually do it. They had looked at Marcus Chen, a 58-year-old civil engineer, a quiet man, a man who had spent 2 years absorbing fines and restrictions and institutional humiliation, and they had concluded that he was the kind of man who complains but ultimately complies. They had confused his patience with passivity. They had confused his precision with timidity. They had not understood that the most dangerous person in any negotiation is the one who has already decided what they are willing to lose. Fitch pivoted. He asked about the drought projections, specifically whether Marcus had consulted with state hydrologists about regional water availability. Marcus confirmed that he had. He confirmed the name of the hydrologist, the date of the consultation, the content of the report. He confirmed that the report projected a significant reduction in regional precipitation over the coming decade, with the most acute impacts expected in the watershed that fed his reservoir. And based on those projections, Fitch said carefully, "Do you anticipate the reservoir's capacity being affected?" "Yes." "In what way?" "Reduced inflow, increased evaporation, potential reduction in storage capacity of between 30 and 45% over a 10-year period under moderate drought scenarios." Another note slid across the table. This time, Fitch picked it up immediately. What Fitch understood, what everyone in that room now understood with the particular clarity that comes from hearing a technical fact stated by a man who built his career on technical facts, was that the drought projections were not hypothetical leverage. They were the mechanism by which the revocability clause became not just legally available, but legally inevitable. If the reservoir's capacity dropped below the threshold required for Marcus's primary agricultural and residential use, he had not merely the right to terminate the easement, he had the obligation to protect his own water supply. The law did not require him to sacrifice his resource for a community he had never joined. The HOA had built 94 homes on the assumption of permanent water. The drought was going to make that assumption a legal impossibility, and Marcus Chen had the documentation, the engineering credentials, and the water rights to prove it. Victoria Ashford had been silent for the first 90 minutes of the deposition. She sat to Fitch's left with a yellow legal pad and a pen she had not used. Her posture, the posture of a woman maintaining composure through sheer force of institutional will. But when Rothstein's turn came, when it was the plaintiff's attorney's opportunity to ask questions of the HOA's representative, who had been brought as a corporate designee, something in her face changed. Rothstein was not theatrical. He did not perform. He asked questions the way Marcus answered them, with the flat, load-bearing precision of a man who had already built the structure and was simply walking you through it room by room. "Ms. Ashford, can you identify the HOA's backup water source in the event that access to Mr. Chen's reservoir is terminated?" Silence. Ms. Ashford: The HOA has been in discussions with the Municipal Water Authority regarding potential infrastructure expansion. Discussions, Rothstein said. Can you provide documentation of those discussions? I would need to check with our facilities committee. Has the HOA commissioned any engineering study regarding the feasibility of connecting to the municipal water system? Another pause. Longer this time. Not a formal study, no. Are you aware of the estimated cost of extending municipal water infrastructure to Willowbrook Estates? Fitch objected. Rothstein rephrased. The answer, when it came, was that Victoria Ashford was generally aware that such an extension would be expensive, but was not in a position to provide specific figures. Rothstein provided them for her. He produced a document, a preliminary infrastructure assessment commissioned by Rothstein's firm from an independent civil engineering consultancy that estimated the cost of municipal water extension at between $7 and $9 million, dependent on route and materials. He entered it into the record. He did not editorialize. He did not say, "And your HOA cannot afford this." He did not need to. The Willowbrook HOA's annual operating budget was a matter of public record. It was $1.2 million. The reserve fund held $340,000. The math was not complicated. It was, in fact, the simplest math in the room. When the deposition concluded 4 hours after it began, the attorneys gathered their materials with the specific efficiency of people who needed to be somewhere else immediately, somewhere private, somewhere they could speak without a court reporter transcribing every word. Victoria Ashford stood, straightened her blazer, and for the first time since she had entered the room, she looked directly at Marcus Chen. It was not the look of a woman who believed she was winning. It was the look of a woman who had just understood, with the full weight of institutional certainty, collapsing into institutional doubt, that the community she had been protecting was not built on solid ground. It was built on an easement. It was built on an assumption. It was built on the belief that a quiet man with a reservoir and a grandfather's deed would never, actually, close the gates. Marcus held her gaze for a moment. Then he capped his pen, closed his legal pad, and stood up. He had nothing to say. The documents had said everything. The drought projections had said everything. The revocability clause, 4 sentences in a 1995 agreement that the HOA's developer had signed without fully reading, without fully understanding, without imagining that the land they were building beside belonged to a man who understood water the way other men understood gravity, had said everything. Outside, the sky was still grey. But Marcus Chen walked to the elevator with the particular steadiness of a man who had spent 2 years watching water rise and had finally, methodically, opened the right valve. The letter arrived on a Tuesday morning in March, delivered by certified mail with return receipt requested, which meant someone at the Willowbrook HOA management office had to sign for it. Marcus had chosen that deliberately. He wanted a signature. He wanted a timestamp. He wanted the moment of receipt to be a matter of legal record, because everything from this point forward was going to be a matter of legal record. David Rothstein had drafted the notice over 6 weeks, which surprised people who expected a document of such consequence to be longer than 3 pages. But that was the thing about precision instruments. They did not need to be large to be lethal. The notice cited Pennsylvania water law chapter and verse. It cited the 1995 easement agreement by page, paragraph, and line number. It cited the revocation clause in language so clean and unambiguous that even a first-year law student could follow the logic from premise to conclusion without losing the thread. The conclusion was this: Marcus Chen, a sole owner of the private impoundment known as the Millbrook Reservoir and all water rights pertinent thereto, hereby provided formal notice of his intent to terminate the non-exclusive water access easement granted to Willowbrook Estates Homeowners Association. Termination would become effective 180 days from the date of receipt. The HOA was advised to make alternative arrangements for the water supply needs of its 94-member households. 3 pages, 47 years of his family's history compressed into 3 pages, and a certified mail receipt. Marcus was sitting at his kitchen table when his phone began to ring. He let it ring. He poured a second cup of coffee and watched the frost on the window above the sink catch the morning light. And he thought about his grandfather standing at the base of the dam in 1987, with mud on his boots and a surveyor's map in his hands, pointing at the water and saying something Marcus had not fully understood, until now. He let the phone ring 4 more times before he picked it up. It was Rothstein. His voice had the particular quality of a man who was professionally composed, but personally delighted. "They have it," he said. "Confirmed receipt at 9:14 this morning." Victoria Ashford signed for it herself. Marcus said nothing for a moment. Then he said, "Start the clock." The reaction from the HOA was not immediate. That surprised some people, but it did not surprise Marcus. He had spent 40 years as a civil engineer, which meant he had spent 40 years watching institutions respond to structural crises, and the first response was almost always the same: denial. Not strategic denial, not calculated denial, but genuine psychological denial. The refusal of people who have built their certainty on a foundation they never examined to accept that the foundation was not what they believed it to be. Victoria Ashford's first public statement, issued through the HOA's community newsletter and posted to the Willowbrook Estates private Facebook group, described the notice as a harassment tactic. She used that phrase specifically, harassment tactic, and she used it with the confidence of someone who had not yet sat down with a water rights attorney and asked the question she